Hi, I'm Elizabeth Talbot, and this is Matthew Talbot, and we're with the Talbot Law Group in Walnut Creek, California, and we are a trust and estate law firm, and one of Matthew's specialties is trust litigation. So today I wanted to ask Matthew about some of the tools that can be used when one is involved in a trust litigation.
Yes, so this can be a very stressful time for people when they get involved with trust litigation. It's important to know the types of tools that you can use to help move it forward and try to get out. Because for most people, the real end game of a trust litigation is just putting it in the rearview mirror. So the first thing to do would be to send out subpoenas. Subpoenas are requests from independent institutions like bank accounts or hospitals, and the purpose is to get these records in an official capacity, financial records, medical records.
What needs to happen before people can use subpoenas to get records, though?
Well, you just have to file the petition. And once the petition's there and you're in the trust litigation, then you can send out subpoenas at any time.
So you have to file the petition with the court?
Or a petition has to be filed, yes.
Okay.
And so that's one type. Another thing that you can do is written discovery. And written discovery are generally to other parties in the matter, maybe the person you're suing or the person suing you, and demands for information or documents. This is incredibly complicated, and we could get down into the really granular level. But just very generally, discovery is something like, please turn over all the bank statements to support your claim, or admit that you took the money from the trust account. Those are very general concepts of what discovery can look like, but it's a written request for information or documentation under penalty of perjury. And another thing that can be done is depositions. Depositions are when everyone gets into a conference room and they take the oath of the deponent and you ask questions as if they're in trial. This is a great way of getting evidence and information ahead of the trial because you can find out what people would testify to at the trial and can go a long way towards settling a case. Many people find depositions stressful and would settle the case in lieu of actually having to be deposed. And the last and perhaps most important thing that can be done to move things forward is hold a mediation. A mediation is a process, a voluntary process I should say, where everybody sits down with a professional mediator to try to work out a deal. It's not about winning, it's not about losing, it's just about trying to get a deal for everyone, get a deal for the client, and put everything in the rearview mirror. So those are the four types of key things that can be done to move trust litigations forward. You have subpoenas, you have discovery, you have depositions, and then hopefully and finally a mediation. And if you have any questions, don't hesitate to contact us. Thank you so much.
Thank you.